the consent of other side. Lordship, conducting counsel, Mr. B. Paul is suffering from high fever, Lordship, so the matter may be adjourned for today.
Okay. Item 34. All sides are represented on the ground that Mr. B. Paul,
B.
General Counsel holding the brief for the petitioner, is indisposed. Commodity medicines adjourned today. List after
Any day, Lordship.
list in the next week.
Deeply obliged, Lordship.
May the Lordships. My lord, item 20 may kindly pass over for 2 weeks. Now.
2. In this case, the LCR is available. It doesn't certain matter.
Next week, my lord. Actually, another item 1 I will do, but sometimes some confusion arises. So, anything in the next week then.
Okay. Next week is please provide Samuel Mohammed counsel for the petitioner. Which says it represented.
Obliged.
May I please your lordship? Lordship, I beg to mention for listing of 2 matters for motion, lordship.
Okay.
Obliged, lordship.
Lordship, we got to item number 31 and 36, my lord. My lord, senior Mr. KKD is out of station, my lord. The matter may be 31 and 36, my lord. To come up for 2 weeks, my lord.
Okay. As prayed for Mr. V.K. Bhagwa, counsel for the petitioner, 2 weeks.
I love that. 31 and 36.
Yes, lordship. I beg to mention item number 8. The matter may be adjourned for today because the engaged counsel will not be able to present today because of some personal difficulties.
21 matter you still want in the motion column adjournment.
Item number 8.
Item A is motion matter
Yeah.
and it's a 21 matter. Your name?
R. Bharani.
I'm already on behalf of Mr. S. Viswas, counsel for the petitioner. After a week. Okay.
Highly applied. May I plead your lordship? Lordship, I beg to mention item number 42, my lord. Matter may be listed next week, any date, my lord.
42.
My lord.
Next week is paid for by Ms. El Wazira, counsel for the petitioner. Okay.
Oblige your lordship.
May I please your lordship? Lordship, I am paying for listing of this matter in the admission file.
Lordship, I beg to mention item number 22. My senior is not present today. Kindly pass for another day.
22. Okay, after a week as prayed for by Mr. Your name?
A.R. Mondol.
A.
A.R. Mondol.
A.R. Mandal on behalf of Mr. S. Islam, counsel for the petitioner. Okay.
Maybe I beg to mention item number 32, Lordship. My senior is under treatment, Lordship. Because Mr. Password for the day, fix and after 3 days, Lordship.
Okay, next week as prayed for me. Your name?
B. Hussain, Lordship.
B. Hussain, counsel for the petitioner.
Interim may be continuous. Interim may be continuous. Interim may be continuous.
Oh, that is the difficulty. In 2000 matter, you are not doing the matter. Interim extended.
Obliged.
Item 25, my lord. My respectful prayer will to accommodate me for a week, my lord. I have personal difficulties today, my lord.
Sorry, it is 2017 matter, my lord, but still I'm seeking adjournment, my lord, for personal difficulties, my lord.
Okay, 25.
Yes,
Yes.
Tapadam.
Wait for me, say yes, Tapada, after week.
I'm deeply obliged.
Wait, please, your lordship. I beg to mention item number 4, lordship. Also, we may pass over for 2 weeks, lordship.
2018 matter, why you are seeking an adjournment?
Lordship, some notification, new notification has come out. I have to get hold of it. lordship.
Yes, okay. Okay. It's paid for Minister
As a summon.
as a Sharma, counsel for the petitioner. Okay. Okay. Yes.
Obliged.
Daily list item 1 for motion.
May I please, lordship? My lord, first, I draw your lordship's kind attention to the party's name, my lord. That lordship may kindly see page 3 of the writ petition. Here, inquiry was held against Minnat Ali. And his sons and daughters' names are also there. But Jamena Khatun, she is the wife of Minnat Ali.
6 days. Yes, what do you want to say?
My lord, my first submission is this. Kindly see the names page 3 of the writ petition.
You see that?
Here, Minnat Ali, there is a reference was against Minnat Ali. And his sons and daughters' names are also there.
Hmm.
Now, petition number 2 is Jamena Khatun. She was also served notice.
Yes.
Now, she is the daughter of Abdul Malik. She will derive her citizenship through her father. So if the two persons are brought in a single reference, then it is very difficult to prove.
Why?
Because, my lord, no independent inquiry was made against this Jamena Khatun. And
No, you see,
my lord, I have some decision. Lordship may kindly see. So, here, my lord, family members, 2019 to 2019 to GLT 61, para
G-
9,
GLT,
GLT 61,
page number,
page number 61, para 9. Sudhir Rai and others versus Union of India and others. Family members of the foreigner does not become foreigners. Automatically, there should be independent reference against against his family members. So now here Jamena Khatun, she has come from another family member. So if she is entangled with me, it is difficult to prove. And not only that, there are other aspects also, my lord, that 2019 6 SCC,
yeah, copies of the judgment.
2019,
You have copies of the judgment?
You should give a list of books. You
actually,
should write a list of books and ask your colleague to furnish it. We can take out the copies so that it becomes easier to refer it.
actually, last night, my lord, I was in hospital. That's why some problem was there. But here, my lord, it is said if nearest person's names appear in the NRC,
No, unless we read the judgment, we won't know.
so in this regard, my lord, I think a lordship may hear the matter, whether this proceeding is acceptable in the eye of law or not. Because husband and wife are totally separate family, from separate family. Now, Binnat Ali will derive citizenship from his father. Now, Jamena Khatun will derive citizenship through her father. So, two independent families are mixed together. So, it has created some clumsiness in proving their cases in a better manner.
That she did not come to adduce oral evidence.
Yes, she did not come.
Yes.
That's why, my lord, that is explanation I have given, my lord. That explanation I have given. Actually, that is the common practice. That problem is there. Lordship may kindly see page 77, my lord. First,
No, this paragraph, this judgment you are citing does not help. Which is only against you, sir. Okay, sons and daughters. You read that judgment. Paragraph 9 you were citing, please read paragraph 9, first 4 lines.
now here, my lord, in short, I have written family
No,
members.
no, writing in short does not mean that that is the intent of the paragraph. The first 4 lines of the letter of the judgment says, as regards the declaration of the wife, sons and daughters of the petitioner to be foreigners, we have perused the records and have taken note of the fact that the reference was made only against the petitioner and not against his wife and daughters. But here the head of the family and all the members, they are being proceeded against. So
All
the
the
judgment will
members
not
are
apply.
there, but wife is not the family member.
Wife is
far
not a
this
family
type of
member. Very
proceeding
good.
is concerned.
Very good.
So far, this type of no wife is not our family member, but to prove this type of cases,
So that we don't know.
she's from totally from a different angle.
No, we don't find that. My wife comes from a different family does not mean
No,
that
no,
she is
I-
not my family member.
When she is married, she is definitely my member.
Huh.
But thing is this, she will derive citizenship not through me or my father. She will derive citizenship from her father.
No, no.
So there was
can't-
no independent
We
inquiry.
can't put the state to so much of for that situation. If you're residing with a with a person who's not an Indian national,
My lord, let
Then-
me satisfy your lordship. Jamina Khatun. Jamina Khatun is the daughter of Mr. X. Now she will get citizenship from X. If there is no inquiry held against X or says Jamina Khatun, then how she will prove that I am not a foreigner, rather an Indian citizen? Because
So
inquiry
you-
should
you-
be held
you
against.
mean to say that a person is married to, say, let us say the person A is married to Z. So whatever inquiry is required to be made will be made at the house of Z.
Yes, her father should be examined. Her father or herself should be examined.
No,
That
no,
you
we
prove your
don't consider.
citizenship.
If that is the case, then we are not, then we don't find any merit. Any other citation you said you are relying on?
And second thing is this, my lord, the family members, close family members, names have been recorded in NRC, then that is a ground that this person is also not a foreigner. That lordship, I am drawing lordship attention. Kindly see. Abdul Quddus case.
Just a moment. Please, please check this LCR and address us on the issue raised by Mr. Mahmood in regard to the reference made to the family against the family members.
Section 35 evidence. Section 35 evidence.
From the records, it is seen, the form number 1. Form number 1, the name of the person against whom the process was initiated was Mannat Ali. Then, my lord, later on, your lordship will find at serial number 9 of the same form. It is that, my lord, Porial, Onyaino, Hodeshwar Nam, Aro Boyok, Janmor Tarikh. There the details are given. Details of the, my lord.
But there's no inquiry, there's no report from
Yes.
any inquiry against other family members.
Yes, but details of their family members have been given.
No. Giving a details of a family member. And inquiry against a family member are two different things.
Yes, ma'am.
So there's no inquiry against the family members.
Yes, the inquiry was initiated against Mannat Ali. That is admitted. That is admitted. Only
And in
details-
the reference made to court,
Yes,
it says Minat Ali and others.
Yes.
And therefore all the persons gave the written statement and therefore they are obtained.
reference it is mentioned, my lord.
Minat Ali and others.
Yes, there is no evidence that they continued. That means the petitioner and the family members continued in India before 25th March 1971. But there are more evidence. There are more evidence that they entered in the India after 25th March 1971.
Oh, that's okay.
is
That's a routine language.
Yes, ma'am.
But if there is no inquiry,
There is no direct inquiry against their other family
family
members.
members.
That is admitted.
I said. We stay the, since you have not issued a notice of motion,
Yes,
we issue a notice of motion, fix a date for hearing in the admission stage. And in the meanwhile that the interim order will be extended.
Yes,
Now tell us within what time you will be ready for hearing?
as your lordship deems fit, we have no problem. But we can go for hearing anytime, as your lordship.
Okay. Okay. Heard Mr. M.U. Mohammed Khan, counsel for the petitioners. Also heard Mr. Payang, you are appearing for Foreigners Tribunal
My lord, the state of Assam represented Home Department.
for the
That is respondent number 3,
3, 5 to 7,
3, 6, and 7.
3, 6 and 7. Okay.
Yes.
Mr. J. Payang, Leonard's Special Standing Counsel for the Foreigners Tribunal, representing respondent numbers 3, 6, and 7. And
Respondent number.
yes, Mr. A.I. Ali, Leonard, Standing Counsel for the Election Commission of India, respondent number 2. Your name?
S. Barik on behalf of S.
S. Parikh on behalf of Mr. S.C. Kyal,
SK Mehdi, my lord.
S.K. Medhi, learned CEC appearing for respondent number 1. And who's for others?
Three will be, my lord.
I am appearing for respondent number 5, Arthur Luther.
Okay, Mr. Arthur Ruger and standing counsel for respondent number 5. Who's for 4?
Four is, my lord, now there is no standing counsel for four, my lord.
There is no standing counsel.
Yes.
Because this is NRC is the central government, so CGC will appear, I think.
Probably, my lord, earlier in some occasions, my lord, notice has been issued.
On NRC.
Yes. Notice to them.
No, we should not issue a notice because
Yes,
this is a central government,
They can be represented by central government also.
central government organization.
Yes, let them.
Oh, no, this is Assam coordinator of NRC.
Yes, madam.
This is a central government organization. Next, para, it has been submitted that normally that as there is no standing counsel for NRC, a notice is required to be issued on the Assam coordinator of NRC. In this regard, the court is of the considered opinion that National Register of Citizenship is a integral part of the central government organization, and therefore we direct the CGC to accept notice on behalf of respondent number 4. Who's to be? In terms of next para, in terms of order dated 28/2018, we have perused the records of the Learned Foreigners Tribunal. And we are satisfied that this is a fit case for issuance of notice of motion. Next para, accordingly, issue notice of motion returnable in 4 weeks. Requisite extra copies of the writ petition be served on the learned state and learned state council, CGC and the learned departmental council in course of the day. Next para, the interim order passed on 28/2018 that the petitioners shall not be arrested and deported, shall stand extended till the next date of listing. Next para, list after 4 weeks.
Hello.
Item 2,
Not a user call for the petitioner. These comments are all represented. And justice, we adjourn the matter. Next,
Item 3.
this item 3.
Item 3. Item 5.
We have produced the migration certificate.
It was call for record whether he is registered.
No, this original record, original migration certificate would be with you. So that is why no orders were passed. You were directed to produce the migration certificate.
My lord, actually, this matter is Mr. Sarkar matter, so my lord.
No, you should be ready. You see, this is a 2019 matter. Whose is this matter? We are not inquiring. We are not inquiring who is the holder of brief, who is the counsel, who is the instructing counsel, who is the counsel who gave you the brief. That is not the matter of inquiry. The inquiry is in 2019. There is an order that you produced a document which are rejected. We directed you to produce a record. Well, what is so? What is that to do with whose brief it is, who is holding the brief? No, don't tell us whose brief it is, from whom you received the brief. These are not the subject matter of inquiry. Simple question that you produced a document which was rejected to be fraudulent. We ask you to produce the document. We give you 2 weeks time to comply with the order. Otherwise, we'll say that adverse orders will be passed against you. Your name?
S. Das.
Mr. S. Das, learned counsel for the petitioner, is present. All the respondents are also represented. Next, brother. In the order dated 27/1/2023, this court had recorded that the tribunal had rejected an application produced by the petitioner by providing that the petitioner had migrated to India on the basis of migration certificate dated 29/5/1966, which was suspected to be a fraud. Stop. Accordingly, the petitioner was directed to produce a copy of the migration certificate dated 29/5/1966, which was relied upon by the petitioner before the learned tribunal. Stop. For the Home Department, who's appearing, you are there?
Yes,
Yes, what is your instructions?
my lord, probably its instruction is there, but I could not get it, my lord, right now. I'll produce it next.
Okay. Next paragraph. The order dated 27/5/2020. No, here you write the last line. First of the learned counsel for the petitioner is not has not produced this record. Next paragraph. The order dated 27/5/2024. This court had directed the learned standing counsel for the Home Department, Government of Assam, to apprise the court as to whether the learned foreigners tribunal, Guwahati, in MFT case number 1620 of 1988, by its order dated 6/6/1989, opined the petitioner to be a foreigner within the stream of 1/1/1966 and 24/3/1971, and that whether, the petitioner, pursuant to the said order, registered herself under the provisions of Section 6 of the Citizenship Act, 1955, by registration number 98 on 19/6/1989 at Guwahati or not. Stop. Mr. J. Payang, standing counsel for the State Home Department, prays for some time to obtain instructions. Next one. List again only. Give a fixed date after 2 weeks. 2 weeks or 3 weeks? How much time you need?
2 weeks will be.
Okay, 2 weeks.
Like,
The petitioner shall send a downloaded, the learned counsel for the petitioner shall send a downloaded copy of this order to the petitioner to put her to notice of her requirement to comply with the order dated 27/1/2023 and to produce a proof thereof before the court on the next date of listing. So next time you give a notice, show us a proof, otherwise we'll dismiss.
Item 6.
List on so and so. To fix the date. Just a moment.
Seventh of August.
Yes, you have instructions. The pen.
Item. There is no instruction, but any instruction.
I earlier ordered it at 9:02. There was a direction to. There was a direction to verify the authenticity of this order. Page 5960.
5960. Yes, sir.
Sorry, my lord, I could not get it, my lord. Can it be fixed day after tomorrow? I'll get it by tomorrow.
Huh?
I will get it by tomorrow, madam. I'm maybe do this time.
Yeah. Okay. The petitioner and the respondents are all represented. This is J. Payang, Leonard. Standing also for the
FD.
for the FT. Takes note of the order dated 9/2/2021. And pays for and is granted 2 days time to obtain instructions as to the authenticity of the document annexed at page 59-60 of the petition, being a copy of order dated 23/6/2016. Not order, opinion dated 23/6/2016, passed by the Foreigners Tribunal Nalbari.
It's-
In the proceedings of FT case number capital M dash 2/100/15. Next one, list on, fixing it on Friday. Friday, 26/7.
I have remembered these cases. There are cases of Nalbari district, my lord. Some cases, these kind of orders were passed. And no separate, my lord, the judgment opinion was passed. And there was no sign of the concerned member. So those matters were called before the Honorable Court in a suo motu matter. All those judgments, all those orders were set aside, and those were returned back from the same stage. Yes. So I'll get the the order of the Honorable Court by the division bench of the Honorable Court, remand back, my lord, by setting aside all these orders, this kind of orders. 14 or 15 numbers of cases were there. One of these cases, probably this is one of the cases.
No, you just
Yes,
pinpoint
I'll
us
get,
with the number and
yes,
this,
I'll
whether
get it,
is-
I'll get it.
Okay. Oh, right.
Item 7.
But your lordship,
Yes,
this
Mr. Dasgupta.
is an ex-parte order. Now, unfortunately, your lordship may come to page 40. The NRC draft list where petitioner's name, petitioner's son's name, petitioner's grandson's names were figured. But unfortunately, because of this case, on ex-parte order, petitioner's name has been deleted. Her son and grandson's names are there. The petitioner is a voter of 1965. That was also at page 19. Because of this ex-parte order, all these things have happened. A Lord Court record has come. In 1966 voter list, her name was there. In the draft NRC, her name, her son, and her grandson's names are there. But ultimately, her name was deleted, but her son and grandson's names are there.
Mr. Pine,
Yes.
please take this. मोटी घुरी है इसे, एक्सप्रेशन हो रहा है। So let's see this.
The orders that she appeared and filed the WS.
No.
If you look at it.
Oh.
A notice was issued to the church. A OP appeared and so did short time for filing WS. Page 24.
No.
Date of something else.
What is the explanation why she did not contest the matter?
Actually, I have checked up the record. It appears from the record, it appears that 18/12/2007, as per the record, opposite party appeared and filed an application number 2484, and adjourned and granted 6/31/2008. But 2484 application is not there. Probably it has been misplaced, or it is an application of somebody else.
What is the date?
18/12/2007. It may be one of the reasons. I'm not very much sure of it.
Yes. It was,
Is it? I know it didn't.
is it petition? This is a point that petition is not here. There is a petition of
2484. Number
29/9/2007. Yes, this has to be set aside and sent back. Something wrong. There are 3 flags here. The service report is on that date. It has come. The net date is fixed as per the order sheet. And then the other petition is not here. Mhm.
On 18/12, my lord, there is a petition.
Yes, number two petition.
Where is it? It's not there on record.
Petition is available.
Yes, 1812, there is a petition.
Again,
Adjournment.
No, this is 99. This is 99. It was put up on 1812.
Yes.
Oh, acha.
Due to flood, she could not appear, my lord, that is.
Yes, Mr. Dasgupta, you were given an opportunity and thereafter you did not appear. Lot of time was granted to you to file your written statement. Even in the absence of counsel, a lot of opportunities were given.
Actually, on 1812, he was not aware of that date, 18/12/2007. He filed an application on 19/9, I am told, no?
No, 99 was not the, 99 was the not date fixed.
Oh, yes, that was the
It
problem.
was an off date. On off date, you find and there is an order to put up on the date fixed. On that day, after that, you did never
On
appear.
that day, he has not appeared,
No.
because he was not aware of that. No, otherwise, my case is a good case.
No, but first the ex parte order, you have to demonstrate that it's a fit case to set it aside. Only then examine the merit. Because Mr. Dasgupta, the order by which the proceedings was ordered to proceed ex parte against you, that order is not under challenge. So unless the ex parte order is set aside, the
No, that particular order is challenged only.
because other, you can take a point that the ex parte order
19/12/2011.
1812. No, 1812 you're not ordered ex parte. Ex
19/12.
parte order is no, not it's 1812, but it's not on that. The of Nani Babe. There is an order of 5/2/2009.
19/12/2011. Ex parte order.
No,
That is the disposal of the reference. If you see the order at page 25, para 5, it was disposed of ex-parte.
In favor of the state.
Exactly. So the fact that it proceeded ex-parte, there is a prior order.
Of 5/2/2009. 5/2/2009, you check this. There's an order of 1812. You are not present on 31/3. You were given another opportunity. Then again, another opportunity on 7/7/2008, 12/10/2008. Then 5/2/2009 is the order to proceed ex parte.
Then ex-parte order was
So
given.
therefore, ex parte order is not on a challenge. Now we'll have to go into the merit of whether the order is right or wrong.
Expert 1912-2000.
No, there's no order of 1912. Pink flag, I have opened it up for you. You see the first order left side. No, the flag page. Pink flag. Left side page, first order is 1812.
1812.
So this order was not ex parte. Next page, right side page, first order is the ex parte order. This order is not a challenge. Therefore, we'll have to go into the merit of the order opinion.
It will proceed ex-parte.
So this order is not a challenge. Therefore, we go into the merit of the order. So in merit of the order, there is no written statement, there is no evidence. So you have to convince us that we can go through the record which was not available before the learned tribunal.
We have to challenge 5/2009 order.
I can't say, we are just hearing you. We can't say. We can't say what, but maybe that, but we are just,
Technically, it appears to be.
we are enriching ourselves with your argument.
Some time being arrived. That was not my case. And so
No.
far the government stand, at present government stand is concerned, and otherwise documents are concerned.
No, we don't know, because strictly speaking, we have to enter into the merit. We give him 2 weeks, okay.
So it's called an amendment petition.
We won't say, because we told you we are enriching ourselves with your
Actually, this
submissions.
order was not with me.
On the prayer made by Mr. A. Dasgupta and a senior counsel assisted by Ms. B. Das, counsel for the petitioner. The matter stands adjourned today. All the respondents are represented. List after 2 weeks.
Let it be 4 weeks.
Okay, list after 4 weeks.
I may have to file an amendment.
Okay.
Now, may I take the certified copy from this?
Yes, I think you will be permitted. We permit certified copies from the LCR. Mr. Pai?
Yes.
Generally, we can fund.
That can be written.
No, it's not required. LCR, you can get certified copies.
So I can collect certified copy from the official High Court official. From the High Court itself, we can.
Yes, you can do it. Since the LCR is here, you are permitted to take copies from the LCR. This is an order sheet.
2009.
Why?
Item 9.
May I please your lordship? My lord, this is a contested case, my lord. The impugned order of page number 39. After the impugned a day later, the petitioner was detained, my lord. My lord, before taking your lordship through the impugned order, can I take your lordship through annexure 2, my lord?
Page 29.
Page 29, my lord. May I read, my lord?
Give the relevant part because this is only a form.
My lord. My lord, the column 6, it reads address in India, village number 2, Tamuldi, police station, Boko, Kamrup, state Assam. Now, my lord, from the next page, which is the vernacular, the original form, my lord, it says untraced, my lord. The petitioner was untraced, my lord. The next page number, my lord, page number 33 now, my lord. The entire form says untraced. May I read, my lord?
Yes, yes.
My lord, page number 33, again, my lord, address in India is Tamuldi, Kamrup, police station, Boko, Assam. Next page, my lord, page number 34, my lord. Page number 34, this is under column finding of the inquiry recommendation, my lord. Now, page number 34 says, during my inquiry that the suspect, Mr. Mohar Ali, son of Jasimuddin of Jorabat, Tiniali, is found untraced. Nobody can say whereabout the suspect, hence the case to SP BCT Guwahati for further necessary action, my lord. Now, my lord, if I can take your lordship through this vernacular, my lord, the certified copy that has been provided to us. So, entire thing, my lord, it says untraced. Entire thing is untraced, my lord. Now, my lord, this investigation was done at Jorabat, where the petitioner came to work as a migrant labor, my lord. Now, his original address was there. And this is, my lord, 2001, when I presume, my lord, both the place, the Boko police station and Jorabat police station was under the same superintendent of police, my lord. They could have certainly traced this person. And when the notice was issued, it was issued to this Boko police station, and he appeared before the learned tribunal. Now, my lord, the 1964 order, my lord, para 21A, my lord, 1964 order.
What is? So, what is strategy?
My lord, I can give my copy, my lord. Para 21A, my lord, I have also noted it in the, I will read from my petition. It has been flagged. My lord, 1964 order. May I read, my lord? My lord, it says,
Yes, yes.
My lord, it says the central government or the state government or the union territory administration or the district collector or the district magistrate by order refer the question as to whether the person is not a foreigner within the meaning of the Foreigners Act. Now, my lord, this section gives the mandate to the learned tribunal. The jurisdiction has been given by this section, my lord. Now, when the inquiry report says that the person is untraced, my lord, there is no allegation against the petitioner. So there is no, my humble submission before your lordship is that the tribunal had no jurisdiction to try this matter. And also, my lord, there are judgment of this honorable court. Para 47, my lord. Page number 9, my lord, para 47.
Yes.
May I read, my lord? It says, we are of the view that the aforesaid submission has to be first addressed in as much as if there was no proper inquiry. The subsequent act, including the reference made, the proceeding before the tribunal may be vitiated and the opinion of the tribunal may not be sustained. If the foundation goes, the superstructure would collapse. Therefore, if there has been no proper inquiry or any allegation, not tentative finding by the inquiry authority that the petitioner had come from the specified territory within the meaning of Section 6A of the Citizenship Act 1955, it is doubtful whether the subsequent proceeding before the tribunal would be sustained or not. Not completely covered. My case is
No,
completely
it's
covered.
not covered. In your case, there was an inquiry and your statement was recorded in 2000.
My lord. But there was no allegation, my lord.
And thereafter, the statement of witnesses have been recorded. But Mr. Pai,
Yes.
you know, to tell us if here his statement is recorded,
Yes.
then this subsequent act of the SP border say that he was absent. To say that he was absent is they put a flag here.
Yes.
This man's LTA was taken. And thereafter, it says that man is untraceable. See in the bottom, his LTI is there.
Yes.
Then
My lord, what happens, my lord? The procedure here is when the person is suspected, he first of all detained. First, on the first day, when he is suspected, his statement is recorded. And he is given 10 days time to produce
no,
documents.
untraced. Why in the form?
Yes, my
You
lord.
say untraced.
Yes, my lord. What, my lord, in fact, these forms are of IMDT types, my lord.
Pardon me?
IMDT tribunals,
Yes.
IMDT types, my lord. There were forms, mandatory forms in the IMDT, my lord. Those are not applicable as on now, my lord. In fact, the Honorable Apex Court has set aside the IMDT. And in that IMDT, it is clearly said that those forms, the requirement of those forms are not possible on the part of the state to fill up because they will not disclose everything, whatever is necessary there in the mandate forms. And those, I'm not coming to that. Those has been set aside, whatever it may be, madam. The procedure that was then, madam, accepted was followed was, madam, once he is inquired, he is to given 10 days time to produce his documents. then my lord, when he is asked to produce, he will become untraceable. That is the procedure in almost all cases you will find, my lord. And
Mr. Payan, then what the concerned officer who has done the inquiry will say that on so and so day, he was asked to produce records within 10 days.
yes,
Correct. So where is that satisfaction recorded? Because the officer, the inquiry officer writes he is untraceable. Untraceable does not say from which date he is untraceable.
my lord, as per his statement itself, and the last and the state statement as your lordship has shown. আজি 24/7/2000 on that particular তাৰিখে আসামি যোৰহাট আৰক্ষী চকীৰ পুলিচে আহি মোক ভাৰতীয় নাগৰিকত্বৰ প্ৰমাণ পত্ৰ বিচাৰে মই একো দেখুৱাব নোৱাৰো 15 দিনৰ ভিতৰত মোৰ পৰা আৰক্ষীয়ে চকীত মোক দেখুৱাবলৈ ক'লে অন্যথা আইনমতে বিহিত ব্যৱস্থা ল'ব ওপৰৰ কথাখিনি মোৰ পঢ়ি শুনি ইয়াত মই বুজি তলত সই কৰো so he was given 15 days time to produce the documents. That was the this is my lord initial statement. Then my lord, your lordship will find this is of my lord 24/7/2020 to 2021 my lord 2000. Then next on 17/9 my lord 17/9/2001 FIR was registered against him. FIR was registered against him.
That statement is that statement is dated.
Statement is dated 24/7/2000 my lord. As he could not produce the documents within 15 days, the FIR was registered my lord. On this is on my lord 17/9/2001. Here, my lord, information has been furnished to me that the person whose name and particulars are furnished below is suspected to be illegal migrant. You are hereby ordered under Rule 3 of the Illegal Migrants Determination of Tribunal, Rule 1984, to inquire and submit your finding throughout the Circle Inspector of Persista PS and the local serving committee as early as possible. And at the time committee was there, those matters had to be placed in the committee. His details is given. Mohor Ali, is it about 35 years, son of so-and-so. So details is given. Then there were inquiry conducted by the police matter. Some with evidence of statements were recorded of some witnesses, my lord. 2, 3, 1, 2, 3. Three witnesses were recorded. Witnesses of 3 persons were recorded.
Yes.
And during the process, my lord, these 2 forms, Form 1 and Form 2, these were mandatory under the IMDT Act, my lord. Those were filled up. Those could not be finally filled up because he become untraceable after the, my lord, initial inquiry. Only once he has given a statement, then he become untraceable. Then lastly, my lord, the reference.
Just on hold. Just a minute. One second. Yes.
Look, I have even the page number here in this record. And the last part of the case diary, it is, my lord, observed. Etia moi, my lord, he went to the place. Etia moi, সংগী সহ আৰক্ষী চকীত হাজিৰ হওঁ আৰু উক্ত গোচৰ সংক্ৰান্তত স্থানীয়ভাৱে তদন্ত কৰি সাক্ষীবাদীৰ জবানবন্দী লৈ জনাও যে উক্ত গুণত উল্লেখ কৰা সন্দেহী মহম্মদ চয়েনচো পিতা চয়েনচো আলি এজন অবৈধ প্ৰব্ৰজনকাৰী ব্যক্তি। তদন্ত কালত জনা গ'ল যে তেওঁ যোৰাপাট আৰক্ষীৰ পূজা মণ্ডপত ভঙা চিঙা লোহাৰ ব্যৱসায় কৰি আছিল। তেওঁ ভাৰতীয় নাগৰিকত্বৰ প্ৰমাণপত্ৰ বিচৰাত যোৰাবাট বৰুৱাবাৰী পূজা মণ্ডপৰ আগবাঢ়ি গুচি যায়। এৰি গুচি যায়। স্থানীয় সাক্ষীবাদী ও তদন্তকাৰী গণ্যমান্য ব্যক্তিক সোধপোছ কৰাত সন্দেহীৰ কোনো সন্ধান উলিয়াব নোৱাৰিলো। ইয়াৰ পৰা জানিব পৰা যায় যে সন্দেহী এগৰাকী অবৈধ প্ৰব্ৰজনকাৰী ব্যক্তি। তেওঁ মাক বাপেকৰ লগত ভাৰতত 1971 চনৰ 25 মাৰ্চৰ পিছত প্ৰৱেশ কৰা বুলি সন্দেহ কৰা হয়। গতিকে মোকদ্দমাটো অধিক সময় তদন্ত কৰি পেলাই তাৰিখ যথাবিহিত ব্যৱস্থা ল'বলৈ আৰক্ষী অধীক্ষক সীমান্ত মহোদয়লৈ গুৱাহাটী মহানগৰত প্ৰেৰণ কৰিলো। So he had submitted this report, my lord. And this is
Okay, we are issuing a formal notice and we'll take it up for disposal at the admission stage.
Lord, I have filed an IA, my lord. I'm in detention for the last 4.5 months.
No, I don't think you have made out a case for being released from detention.
Lord, my respectful submission is that, my lord, I can also take your lordship through the document merit of the case, my lord. But firstly, my lord, my respectful submission is that there was no jurisdiction, my lord. The form says untraced, and the entire thing, my lord, my respectful submission is that should be read in the light of the recent Rahim Ali judgment.
Mr. Pang has demonstrated that this initially your statement was taken after you were given opportunity to produce the documents.
My lord.
You vanished. So therefore the tribunal would have jurisdiction. You're taking it up after 2 weeks. You would
My
go to
lord,
the LCRN. This is the motion stage.
let a notice be issued.
Lord, on the last occasion, your lordship had observed that after the LCR is here, your lordship will decide on the interim, my lord. On the IM.
We are not inclined.
By then I will release, my lord. This is my respectful. I will
No, interim we don't find. Issue notice on the, because rejection will again be against you. We should notice on both of them. We take it up together. Your name?
A.W. Aman.
Mr. A.W. Aman, learned counsel for the petitioner. Mr. J. Pang, learned standing counsel for the PC. Mr. You're appearing for?
Lordship. Yeah, it is same years.
Also for two.
Yes.
Your Lordship, I'm appearing for Election Commission of India, respondent number 2.
That's right. J. Barbar, learned P. Barbar, I'm sorry. It's P. Barbar, learned CEC appearing for the Union of, for the Election Commission of India. Mr. S.K. Mehdi, learned CEC for the Union of India.
I'm for respondent number 4, Lordship.
Mr.
R. Talukdar,
R. Talukdar, learned
appearing for respondent number 4.
standing counsel for respondent number 4. Next para. In
Respondent number 4, Deputy Commissioner.
5, 6, 5 I will appear.
Hmm?
The Home Department I will appear.
Okay.
Whatever is there. The state respondent number 3 and 5.
Oh, Mr. Mehdi, for 6 you will have to appear. NRC is a government of India organization. NRC, we are not issuing notice because it's a central government. Either you give us a letter from the secretary saying that this is the government will not appear, CEC will not appear for the NRC, then it is separate. But if it's a government of India organization, we are not issuing notice on them by registered post. For CEC, right, for respondent 1 and 6. In terms of order dated 15/5/2024, we have here is the trial court records. The records received from the Foreigners Tribunal.
23.
If you notice, returnable in, give a date after 2 weeks. You should notice, including notice on the notice on PA Civil 1386 of 2024, returnable on 7/8/2024. Requisite extra copies of the petition be served on the learned to the respective learned counsel for the respondents. Full stop. The objection, if any, in the interlocutory application shall be filed by the respondents within next date of listing. Next para, list on same date.
Deep problem.
Extra copies you said.
Oblige.
Okay. Also, is a represented on the plan made by Ms.
A. Hussain.
A.
Hussain. Hussain.
Hussain, learned counsel for the petitioner. The matter stands adjourned today, list after a week.
Right.
11,
Please, your Lordship. 2014 minutes, I have been declared for Indian at page 42 by FT Nalbari. Subsequently, in 2023, they declared me, FT number 4 Nalbari declared me as a foreigner. So, the law is settled by the principle of res judicata will apply.
Where is the earlier order?
At page 20, earlier order is page 42.
Where is your father's document of 6-1 of the Citizenship Amendment Act?
I'm sorry, my lords.
You said it's projected in this order that your father was a citizen of India.
Yes.
Where is that document? Page 44, you made us read. In 44, it says that as per the provision of 6-1, your father was a
6-1.
citizen of India. Where is the document in support of that?
It must be, we must have produced, I have not.
No, don't say must have produced. You are now in a writ petition. You made us read paragraph, this page 44, we are reading it and then asking you a question.
If the records may be called for, we'll see. And also, any document is not necessary because I have annexed 1966 voter list at page 45, 46. So it's imperative that I am a citizen of India. That my father is a citizen of India. At page 46, 47, my name appears, my father's name appears, Kitab Ali.
Was the earlier order placed before the tribunal?
Yes, man.
Does it find a reference here?
I'm sorry, man.
Does the earlier order find a reference in the subsequent order?
Yes, but that is at page 22. Right? The order does mention about the earlier order, but it doesn't engage with it. It provides no reason why.
Where is that? Show us that.
Page 24. Let's in para 22. May I read? Page 24. Fifth para. May I read, madam? In para 22 of the written statement, OP stated that previously one FT NAL case registered white FT and NAL case number 2543/2006 in the name of the OP. The OP contested in the case Honorable FT Court opinion that the OP is an Indian wide order dated 21/6/2014. Now, this order does acknowledge the previous order, but it doesn't give any engagement. It doesn't provide any. Subsequently, there is no mention of this order. That's why the Honorable Tribunal thinks, and I have been declared for it.
Your name?
DK Agarwala.
Hmm?
DK Agarwala.
Mr. T.K. Agarwala, can you counsel for the petitioner? Learned counsel, appearing on behalf of the counsel on the, for the petitioner on record. Also have Mr. J. Payang, learned standing counsel for the FTC. Mr. Sharma, you are appearing for?
Yes, Lord. 2 and 5, Lord.
2 and 5. Mr.
G Sharma.
D. Sharma.
G.
G. Sharma, I'm sorry. This is G. Sharma, learned counsel for respondent number.
3 and 5.
Learned government advocate appearing for respondent number 3 and 5. For election commission, you are there, Ms. Sri Barbar, learned standing counsel for respondent number 2. Union Freedom Mr. Mehdi, unless Mr. S.K. Mehdi, learned CC appearing for respondent number 1 and 6.
And 4.
For 4, this is R. Talukdar, learned G. Assam appearing for respondent number 4. The petitioner was declared as a foreigner by the Foreigners Tribunal Nalbari by order dated 28/12/2023, passed in FT case number within bracket GH bracket close 1416 of 2018. No, not this.
Page 22.
Page 22.
It's 20.
In Foreigners Tribunal Nalbari 4th within bracket Gograpar, Assam in no.
Go to below.
No, FT case 1416, FT case number GH 1416 of 2018 is assailed on the ground that the said opinion was hit by the principles of res judicata in view of judgment of the opinion dated 21/6/2014, passed by the Foreigners Tribunal Nalbari in FT within bracket NAL bracket closed case number within bracket N bracket closed 2543 of 2006, wherein the petitioner was declared to be not a foreigner. Expiration notice returnable in 4 weeks. Requisite extra copies of the petition be served on the learned respective counsel for the respondents in course of the day. Let the records of FT case number within bracket GH 1416 of 2018 be called from the Foreigners Tribunal Nalbari 4th, and the copy of who will now produce this copy of Foreigners Tribunal records?
It is.
Foreigners Tribunal Nalbari.
Huh?
That may be communicated to Foreigners Tribunal Nalbari. Lordship.
Okay.
So registry, Lordship.
Oh, Agor order. Agor order, they will produce. Verify the authenticity. That is the point.
Pro registry lot.
Huh?
Pro registry lot, it
Okay.
will go.
The earlier order also.
As well as records of FT within bracket null, NL, within bracket case number, within bracket N, bracket goes 2543 of 2006 from the Foreigners Tribunal, Nalbari. Next para. In view of the decision of the Foreigners Tribunal, Nalbari, as referred above, comma, as an interim measure, it is provided that the petitioner shall not be arrested or deported from India till further orders. Next para. List after 4 weeks.
Much obliged.
Item 12,
Also, we have challenged the order, page 18, Lord, but operation document.
Yes, Mr. Sarkar,
Lordship, page 18, Lordship, impound order, Lordship.
page 18.
18. Basically, this impound order has been passed basically on the ground that, Lordship, the voter list, Lordship, which were exhibited during the trial, Lordship, that was not taken into account on the ground that, Lordship, that were electronic documents. Lordship, in this regard, Lordship, observations of the learned tribunal may be seen, page 24, last paragraph, Lordship. Page 24,
Yes.
last paragraph. The submitted voter lists are verified by OP from the election office to be, but all the voter lists are electronic certified copy of electoral roll, and hence contents of the documents is not proved by the authority, and hence these exhibits cannot telling with the primary evidence, Lordship. That was not considered.
Where is that voter list? Please show us the document.
Page 30, Lordship.
30.
Here is it. And relevant portion, page 31, Lordship. Serial number 542, Abuddhi Sheikh was my father. Page 31, relevant portion, that is 1966 voter list. Next, Lordship, page 32, 1970
Just
voter
one
list. Page 32, Lordship. In serial number 403, Abuddhi Sheikh. And in support of
Just one. Yes, Mr. Sharma. What do you say about this rejection of the voter list at Exhibit 1, page 30?
Yes, Lordship. Yes, Lordship, certified copy. But Lordship.
Tribunal, page 24 last paragraph. Lordship, page 24. Tribunal said, citing the Borhanalis case, Lordship, where
Which one?
last, from bottom three, Lordship. Therefore, in Borhanali versus Union of India, WBC number 7669 of 2000, it was held that the proof of contents of the certified copies by comparing with the primary evidence, that is electoral roll in original, produced and testified by the lawful custodian of such primary evidence, that is by the concerned electoral registration officer or by his authorized officer. And Lordship, at this stage, record may be called for, Lordship.
The judgment cited in the Lordship in Tribunal's order Borhanali. Lordship, that was not electronic portal list, Lordship.
Just a moment. This Burhan doesn't help him, help the state,
Lordship,
Mr. Sharma.
yes,
This Burhan Ali doesn't help the state.
yes, Lordship.
This is a certificate copy.
Yes, Lordship.
In a certified copy, there is no subclassification of electronic certified copy.
Here, proposition was that, Lordship, in Borhanali's case, filing of an unsigned, unauthenticated, and uncertified copy of voter list sought to be relied upon as a
Correct.
proof of citizenship
But
would
look
not
at
be
page
admissible in
24,
evidence.
24 says electronic certified.
But here it is a certified copy, Lordship, I think.
Yes, in certified copy, there is no subclassification of certified, electronic certified
Yes, Lordship.
extract copy.
At this stage, notice may be issued, Lordship.
Same order, notice, hello, interim order, same. Mr. E.T. Sarkar.
Learned counsel for the petitioner. For respondents, it will be same. CGC will appear for respondent number 1 and 4. 1 and 4. Ms. Barba will be for 2.
Yes, no. I am for 3 and lordship 6.
Mr. Sharma, 3 and 6.
I'm only for respondent number 2. Yeah.
And you'll be appearing for 2. Mr. Ayali. First number 2. Same orders will not be arrested and deported. Same order.
Highly obliged.
But you give copies in course of the day, extra copies. Call
13.
From the tribunal. Sorry.
Midfield, Your Lordship.
Yes, Mr. Chaudhary.
Lordship. I have contested this case, Lordship, by exhibiting, Lordship, there are 9 exhibits. And 1966, 1970 voter list of my grandfather.
Why it was rejected?
Rejected on the ground that, Lordship, my father's name appeared in voter list of 1985 and his age was shown as 41 years, Lordship. Prior to 1985, there was no voter list in the name of the father, Lordship. That is one ground, Lordship, and OP has not stated in written statement why her father's name not appeared prior to 1985. And Lordship, apart from being not proved, Exhibit 4, that is a Kabinnama, Lordship, it is a document of prior to 1971. So that was not taken into consideration. That is Exhibit 4, Lordship. Her marriage document, Lordship. And Exhibit 5 and 7, her voter list with her husband, Lordship, these are all insufficient for linkage with father, Lordship. Exhibit 8,
Correct.
there was a Jamabandi, Lordship, to show her linkage
Because
with
this
her
is whatever this tribunal is now holding up till now, which you have read, are all supported by the judgments of this court.
Lordship.
This
Two judgments
what is
were
the
by-
relevancy of this 66 and 70 voters list?
Lordship. 66 and 70, Lordship, that is page 19, annexure 1, your Lordship
Yes.
can receive. My grandfather's name is there, Lordship. And again, in 1985 voter list, against my father's name, my grandfather's name has been shown, Lordship. He is
What is the name of your grandfather?
Ajimuddin and Kamala Khatun, Lordship. Ajimuddin's name was there in 1966 voter list, Lordship. Serial number 95, Lordship. Sorry, Lordship, 439. And 1970 voter list also, my grandfather's name is there, Lordship. Serial number 426, Ajimuddin, Lordship.
Same village.
Same village, Lordship. Shimolabari Pratham Khanda, Lordship.
And what is this 85?
Before that, Lordship, I have annexed 1979 voter list also, that was not annexed, exhibited before the learned tribunal, Lordship. That is annexure 3, page 23. Only instead of my father's name, Horof Ali, here it is written as Torof Ali, Lordship. But against my father's name, my grandfather's name is there, Lordship, Ajimuddin. That was not exhibited before the learned tribunal, but I have annexed with this my writ petition, Lordship. And annexure 4 is the 1985 voter list, page 25, Lordship.
Simulary part 1.
Yes, Lordship. Horof Ali, against my father's name, my grandfather's name was there, Lordship. So there is a linkage with my father and grandfather, Lordship.
This is the impugn order. What is it? What is the reason assigned?
Lordship, page 75 is the impugn order, annexure 20, Lordship.
Yes.
And reasons, Lordship, page 76, from record it appears that, Lordship,
Yes.
third paragraph. OP tried to project Horof Ali as his father, whose name recorded in the voter list of 1985 under Simulary Part 1. OP further projected Azimuddin as her grandfather, whose name recorded in the voter list of 1966 and 1970, Exhibit 1 and 2 under Simulary Part 1, District Gwalpara. It appears that though OP claimed that her father's name is enrolled in the year 1985, Exhibit 3, as son of Azimuddin, wherein her projected father's age is shown as 43 years. Going by the age, his name ought to have been recorded in Exhibit 1 and 2. That is one of the ground, Lordship, with her projected grandfather. OP has not explained anything in her written statement that as to why name of her projected father is not recorded in the voter list prior to 1985. There are no documents brought on the record as regards her projected father's, Horof Ali, being a citizen of India prior to the cutoff date of 25/3/1971. Exhibit 4 is a marriage kabinnama of dated 28/6/1998 in between Surya Banu, daughter of Horof Ali, and Naushad Ali. This document, apart from not being proved, is post to 1971. That is cutoff date of identification of foreigners. In Exhibit 5 and 7, OP's name is shown as wife of Naushad Ali and her age is shown as 41 years. These are the voter list of the year 2014-2005. This voter list rendered itself insufficient to establish linkage with her projected father. Exhibit 6 is a Khiraz Patta number 684 of village Simulabari Part 1, Moja Srijangam in the name of Horof Ali, which bears no date. Exhibit 8 is photocopy of Jamabandi for surveyed village under Srijangam Moja, where order of mutation was passed on 2/8/2014. In this regard, OP has not stated about the land Exhibit 6 and 8 in her written statement filed by her on 2/6/2015. Material facts have to be pleaded in the written statement, thereafter proved AIR 1982, Allahabad 385. National Insurance versus Yogendra Nath Burma. Failure to disclose material facts would lead adverse presumptions. It is also held by our High Court in Musammat Anwara Khatun versus Union of India that variance of pleading and proof is not permissible. However, OP has failed to prove the Jamabandi from the land record of Sub-Registrar Office. Therefore, this document has no evidentiary value. Exhibit 9 is stated to be her voter identity card, wherein her relation name is shown as Naushad Ali. This document rendered itself insufficient to establish her linkage with her projected father.
But Mrs. Chaudhary,
Lordship,
earlier when these matters were taken up by a single bench,
Lordship,
there is a judgment of this court in Rahim Ali versus Union of India. In this case, the non-reflection of the name of the concerned proceedee in the voter list after he attained the age of majority was
Lordship.
taken as an adverse circumstances against him. How do you overcome this judgment?
Lordship, 79 voter list was there, but that was not exhibited, Lordship. As because there is a discrepancy in the name
No,
of
then also he is 43.
Lordship.
In 85, he is 43. So he will be 18.
85, he is 41, maybe, Lordship.
Somewhere it is 43. It's okay, 43 or 41,
43, Lordship.
but he would be in 85. Therefore, he was 18 years.
In 1979, his age was shown as 35, Lordship. Lordship, these are the poor people, Lordship. They are doing their life, passing their livelihood by doing.
So that's
labor,
okay,
Lordship.
but his date of birth would be 1942.
Yes.
No, sir,
So
date of birth would be
1942 and 1942, date of year, year of birth, Lordship.
yes.
Yes, Lordship. And 1942 plus 21, Lordship. He should be first. His name should be enlisted in the year of 1963.
3.
But against his name, Lordship, his father's
No,
name was
just
there,
a moment,
Lordship.
just a moment.
Date of birth is 35, 79. Date of birth would be 1944, Lordship.
43, 40.
If it is 35 on 1979, then 44. Even then, Lordship, his name ought to be appeared in 1966.
We call for the record.
Yes, Lordship.
Last order from Champa. Huh? Same order. Any names will change. This is R. Chaudhary for the petitioner. So, इसके विधि learned CEC agreement correspond number 1 and 6. Sharma learned government advocate agreement correspond number 2 and 4.
Correspond number 5.
Speak Barber. Spelling also correspond number
5.
5. For deputy commissioner will be there. For number 3, Mr. R. Talukdar. Government advocate agreement correspond number 3. Same interim.
Order was passed in the year 2019, Lordship.
There's a the interim order would be order dated, opinion dated 24/10/2019, passed by the learned Ordinance Tribunal, Bongaigaon number 2, Kolhapuri, in DNGN /FT case number 3383/2008. By which the petitioner was declared to be a foreigner of post 1971 stream. It will change. I just already will say that.
Item 14,
Mr. Sharma, what is the current case law of this court on this point? About the non-inclusion of name in the earlier voter list? What is the trend of orders at the present moment?
Lordship, my humble submission is that Lordship, as per section 682 Lordship, Lordship, he has to prove that he should be continuously, he must be proved his continuous residence in this territory of Assam since the year
That is
1966.
another part.
Lordship. Yes, Lordship.
But that's not the question. The question is non-inclusion of name in the earlier voter list. What is the recent trend of judgment of this court on that point?
I will provide Lordship.
item 14,
Yes, my lord. This is ex-parte order, your lordship. Against me, my lord. The page number is 30, your lordship. The relevant portion, the page number is 32, your lordship. Kindly come on paragraph 4, your lordship. Page 32, paragraph 4. My lord, may I read, your lordship?
Yes.
Yes, my lord. Paragraph 4. That thereafter, since his appearance on 29/1/2024, OP remained continuously absent on 4/3/24, 17/4/24, 29/4/24, and 16/5/24, your lordship. On 29/4/2024, the learned Angus advocate of the opposite party moved a petition vide number so dated so praying for withdrawal of Ukalatnama from the proceeding. The order dated 29/4/2024 is quoted below, your lordship. OP is absent, but his learned advocate is present and move a petition vide petition number dated praying for withdrawal for their names from the Ukalatnama. The petition of withdrawal is supported by an affidavit. Seeing the petition, the senior most learned English counsel advocate Mr. Z. Hussain submitted that he, along with his juniors, were engaged in this case and submitted that the OP Mr. Barak Ali is not cooperating in handling the reference case and do not give any heed to his advice as legal counsel, and under such circumstances, OP has made him bound to withdraw him along with his juniors advocates from the Kolatama. Mr. Z. Hussain further submitted that he has handed over the brief of the case to the OP, who has accepted the same. Next page, your lordship, 33. In terms of the above submissions, the prayer of the withdrawal of Ukalatama as prayed for is allowed. The office is to struck of the name of J. Hussain, S. Khatun, R. Khatun, and I. Hussain from the record, your lordship. And in this regard, your lordship, I am declared honor, your lordship. And for this ground, your lordship, my explanation is there, your lordship, in my petition, your lordship.
You see, we are not getting your explanation because of the fact that the orders by which the proceeding was ordered to proceed ex parte against you.
Yes, my lord.
That part of the order is not under challenge. So you will have to address us on merit of the opinion.
My lord, only 2-3 dates, first date I was API, your lordship.
You see, I'm repeating it again.
Yes, my lord.
The orders by which the proceeding was directed to proceed ex parte against you are not assailed in this writ petition. Therefore, what is assailed in this writ petition is only the final opinion. So please address us only on the final opinion. Why your lawyer absented, why your lawyer did not inform.
Yes.
These things are not a part of the inquiry at present in this writ petition. Because those orders by which proceeding was ex parte is not under challenge.
And I have challenged this, your lordship.
Please see, show us.
Yes, my lord.
Show us where
Kindly
you have
come on
challenged.
page number 8, your lordship.
I have read your prayer.
Yes,
Read your prayer and please tell us what is under challenge.
page number, yes, my explanation is there, your lordship. Para 10.
No, explanation you
Correct.
see.
Yes, my lord.
Now let us take one of the horrible examples I can give. In the writ petition, supposing you start writing in the writ petition, paragraph 1, High Court to Supreme Court and Supreme Court to High Court. Correct. Paragraph 1, 2, 3, 4, 10 paragraphs in the writ petition. Everything is same. Correct. And now the writ petition is dismissed. In the writ petition, we have challenged, we have given an explanation as to why their order is bad in an intra-court appeal. You write that. Now please tell us, in this situation, when you don't challenge the contents of the writ petition, what would happen in an intra-court appeal?
My lord, for challenging the order, your lordship, I have some grounds, your lordship. And the grounds on para 10 and 13, your lordship. This is the grounds to grounds for challenging this order, your lordship. And why I am declaring.
Mr. Rahman, we can give you hint. We can't explain it to you.
Your lordship. I'm sorry to say.
We can give you a hint. If you can't understand,
And I don't
you take the risk. If you understand, please continue. If you don't understand, then also continue.
Well, I don't understand. Your lordship. I'm sorry. At 2 p.m. your lordship.
Don't understand, ask somebody else.
Yes, my
We can't explain
yes, my lord. I have
what we are trying to say. We can give you a hint. If you can't explain, take an adjournment.
yes, yes.
I can't explain whatever I'm trying to say
2 p.m. as soon as possible. Or next date.
on the prayer made by Mr. P. Rahman, counsel for the petitioner. The matter stands adjourned today.
I am yes Islam, your lord.
Huh?
I am yes Islam. I am yes Islam, your lord.
Oh, okay, as Islam.
Yes.
Okay. Matter stands adjourned today. All the respondents are represented. List after a week. Oh. Could you be, Mr. Sharma and Mr. Talukdar and Mr. Mehdi, my brothers, we suddenly remembered we did not pass any orders in the interim order to take a bail or to not to leave the jurisdiction. You also did not tell us. You have a copy of those interim orders passed earlier?
It is said that we pay bond of 5,000.
Yes, Lord.
Before the biometrics.
Yes, Lordship.
The local.
Try to find out if you have a copy of the earlier order so
Yes,
that
Lord.
these conditions can be incorporated. In some file, you may have copies of orders. Just try to find out. I'll try you. बिल्कुल कॉल कर दियो
Item 15 for admission.
May please, your lordship.
Yes.
May please, your lordship. Lordship, this is an ex-parte opinion, my lord. Petitioner declare foreigner, post of 71, my lord. Opinion is page 42, my lord. My lord, in this case, my lord, the petitioner and their earlier entire family member was declared Indian, my lord, initially, my lord. This is the second proceeding, my lord.
Where is the opinion?
Opinion, my lord, page 42,
42.
lecture 7. Just application. Okay.
Where is the earlier opinion of the IMDT?
Lord, earlier opinion, my lord, page 35, my lord. Page 35, my lord. IMDT, my lord. IMDT, my lord. Little.
What is the explanation for not? What is the explanation of not being able to contest the matter in before the foreigners tribunal?
My lord, some old ushers of the blazer, my lord, addressed to me. Some old ushers of the blazers addressed to me. Earlier, you are declared Indian earlier, so you don't go to appear before this tribunal, my lord. So, my lord, we don't appear second time before this tribunal.
Oh, you have advisors.
Advisors, my lord. But I am the illiterate person, my lord.
An earlier order was not placed before the tribunal.
Not, my lord. I have not appeared before the tribunal second time, my lord.
You deliberately not appeared.
Deliberately, not deliberately, my lord, some old letters of the villager, my lord, advised to me, don't go appear, will not to be appeared before this tribunal, because of that, you were declared Indian earlier, my lord. And
So
there-
now your
there is
well
a-
wishes will be out and you will be in Bangladesh.
There is the judgment of the Supreme Court.
What does it say?
My lord.
What does it say, Abdul Quddus? What does it say?
Abdul res judicata applicable, my lord. Res judicata applicable, my lord. Second procedure may be quashed.
It says that Abdul Quddus.
Abdul Quddus, my lord, check. 2019, 6 HSC, page 604.
2000?
2019.
Which paragraph?
Paragraph 8 and 9.
Paragraph?
I have only one copy, my lord.
No. Again, you must have some advisors. You take only one copy. Before a division bench, place it. Where is the tribunal's finding? Which page?
My lord, earlier
Yes.
opinion, my lord.
Yes.
Earlier opinion, my lord, is, my lord, 35 to 35, my lord.
35 to?
35 to 41.
But you see, you will fail here also. Because 35 to 41 is number one a type copy.
Yes, my lord.
Page 39, 40
39, 40.
is only a type, is only a photocopy.
Photo, yes, my lord.
So it's still not a certified copy on which we can place reliance.
Lord is certificate, my lord. State assistant illegal.
Hmm?
Photocopy.
We'll continue to because this is not a certified copy before us. We don't have anything on record to show that there was an opinion. Neither those records are there before the tribunal, nor those records are there before this court.
This is the original copy, my lord.
No, we don't know. How you present your case is your lookout. Because the document is before us is only a certified copy. You have an original copy.
Oh, my lord, I have also Xerox copy, my lord.
Then you dismiss your petition then. Again, you have good advisors. You don't produce certified copy before us. You can't take cognizance of.
Initially, my lord, LCR was called for, my lord, it may be, my lord, along with the LCR, my lord, original copy is along with the LCR, my lord. Both the cases, LCR was called for, my lord.
11, 12, 13.
Yeah.
So, 12 to 8. There will be some correction in the order. Huh? We'll continue at 2.
Item 15.
May I please, your lord.
Yes.
Past proceeding, whereas I was declaring Indian, my lord. In this case, my LCR may be called for, my lord. But this is not certified copy, my lord. I examine it.
Both sides are represented. Of the plain Mr. I forgot your name.
F.A. Hassan.
And Mr. F.A. Hassan, counsel for the petitioner. The registry shall call for the records of IM case number 254/90 under section 8 within bracket 1 of the IMDT Act, 1983, which was disposed of by IMDT, Sonitpur, Tejpur
Yes.
by order dated 13/1/1992. Now, from where we'll get it, Mr. Sharma?
Lordship,
From where will we get this order?
Lordship, I think Lordship, Nalbari from Nalbari one.
No,
That's good.
illegal
Not
matter.
Tezpur. Not Tezpur.
From where?
Tezpur, Lordship.
No. From which court will now get it?
Tezpur one, Lordship.
Foreigners Tribunal,
Yes,
number 1.
Yes, Lordship.
Okay, Foreigners Tribunal, from the Foreigners Tribunal, number 1, Sonitpur, Tejpur. List of folks.
Items 16.
In this case, your Lord, the petition number 1 has already been reported. But so far, the petition number 2 is concerned in last occasion. Instruction was sought, your lordship. Okay, yes.
Lordship, in this case, Lordship, Deputy Solicitor General of India should be present, Lordship. The Rohingya matter, Lordship.
No.
His presence is required, Lordship.
Whose presence?
Deputy Solicitor General, Lordship. He is handling the Rohingya matter, Lordship.
No, you can still get it without even them being a party. Because
The order permitted him to get the instructions.
because there's an order to enable you to get instructions. The Deputy Commissioner Karimganj is a party here.
Union of India, Lordship. Deputy Solicitor General. Union of India represented by Deputy Solicitor General, Lordship.
Okay,
His presence should be.
okay, he's here. Deportation of Myanmar nationals.
Yes, Lordship, Rohingya.
Okay, because in the
I think
in the office memorandum, there is reference to Myanmar nationals.
yes, Lordship.
It doesn't say about Rohingya or something. It doesn't sub-qualify the.
Myanmar.
Myanmar.
In earlier occasion, your lordship, it was submitted for want of verification. No, because you see, Mr. Khan, now where are the documents to show that they have been declared to be a Myanmar nationals? Because the subsequent inquiry will come at stage 2.
In the
Because
order,
otherwise for the government to identify a particular person is very difficult.
in the order it says, your lordship, they are.
Which order? You are referring to which
Page
order?
16, your lordship.
Huh?
Page 16, your lordship.
15,
16.
16.
Presence is required, I may allowed to call him.
Pardon me?
Architect's presence is required.
No, we don't know. It's not a question of Mr. What do you call, Mr. Arkady Chaudhary, but it's a question of any CGSC telling us what is happening.
Actually, I've no,
Just a
I'm
moment.
not dealing this case.
Okay.
In 27, 2022, that order, your lordship may find it.
I think in this particular order. Just to win the poem. This one.
Seven generation.
This one maybe years ago. Same thing here also.
You see, Mr. Mehdi, who was referring in the matter earlier, Mr. RKD Chaudhary, please call him.
Yes, ma'am.
In some cases, Lordship, State of Assam has wrote a letter to Union of India, Lordship, for verification of regarding their nationality verification, Lordship.
You see,
But in this case, Lordship,
you see,
Lordship,
you, two of you, that is you and the Union of India, they are not acting in tandem. One is not knowing what the other is doing. That is why these issues. And the documents are here, but you are not being able to connect it. There are documents, but you are not able to connect it. There's a just. Twenty-two letters are available. 1920, 22, in 2020, we are requesting you. If you power, I will request for I don't know how. This is another additional political. A letter to the Assam government is a very good story. Understood.
Affidavit has also been filed, Your Lordship, by respondent number 3, saying that they have taken.
Nothing will happen in this case. There will be public come. You see, these documents were here in the court long back. But just as I told you, the state of Assam and the government of India, they are not working in tandem.
Yellow flavor.
There's a yellow flag. You see, Myanmar government in 2019, December, tells you that we could not verify the address of Mohammed Habibullah.
Yes,
Now, had you known this, you could have just asked this man in prison, who is in detention center, as to what is the address and send it to the government of India. After 2019, you are getting letters from the government of India addressed to the embassy of Myanmar regarding these people. So how would something happen You're not even sure what is required, what is the requirement, what should be the, what should be addressed. So these people will never go, and you don't file affidavits.
It did come up tomorrow, Lordship. Tomorrow, day after tomorrow, Lordship.
Day after tomorrow, not tomorrow. What size is it represented?
I could have out of Sunday.
Tomorrow, day after tomorrow, then Friday. Friday, your lordship, it will be better.
Next. Next Monday, man.
Next Monday then, because we are not, we are reserving few days of hearing days. So. All sides are duly represented. Ms. P. Devi, L. Devi, Leonard Counsel. Praise for an adjournment on behalf of Mr. R.K.D. Chaudhary, Leonard DSGI. Prayer is allowed. List on 29/7/2024.
Like the name of Mr. R.K.D. Chaudhary because.
Okay, the next paragraph. The registry shall reflect the name of DSGI in the cause list while listing the matter next. His name is already there, ASGI. In the cause list, item 16. This is item 16.
Yes.
ASGI is already there. Don't write that. Last rank is not required. Okay.
All right.
Item 17.
Please, your lordship.
Yes.
By virtue of the order passed by the tribunal, page 31, my lord, that is dated, my lord, on 29/6/17, I was declared foreigner that I came to India after 1971. My lord, I take your lordship, page 13. My father entered to India in 1956. Page 13,
13.
By virtue of the migration certificate issued by the Indian High Commissioner, region Pakistan. And I entered through Dauki border, my lord. Your lordship will find certified das the Rajkumar Das, my father, the son of late Sir Kushal Chandra Das, aged 28 years, migrated to India with following family members with migration certificate such and such, dated 18/4/56, issued by the Deputy High Commissioner for India at Pakistan in Dhaka to settle at Tetarabari in the district of Kamrup in Assam. This is the certificate issued by the Dauki passport check post, my lord. It is handwritten. Next page is the handwritten, my lord. Page 14. Entry serial number is there, 25/6/56, serial number such and such. Immigration check post.
Who has proved this document?
Dauki, my lord.
No. Who has proved this document?
It was issued in my father's name, my lord.
No. Who has proved this document? Before the
We have
tribunal?
exhibited it before the court, my lord.
Exhibit number?
Exhibit number,
Exhibit I.
yes, my lord. Exhibit I. Copy of the said certificate. Proved in original. The opposite party again deposed that there is a Assam Refugee Federation certificate. Initially, he took shelter under refugee, my lord. The opposite party again deposed that there is a Assam Refugee Federation certificate, white serial number such and such, in the name of his father, exhibited in the said certificate. Exhibit 2 proved in original. The opposite party further deposed that there is a land revenue receipt, serial number 137, dated 13/12/65, issued by the Mojadar in the name of the father of the opposite party, and exhibited a copy of the said land revenue receipt. Exhibit 3 proved in original. In his evidence, the opposite party deposed that he is a citizen of India by birth, and his father, mother were also Indian citizen by birth. In his additional evidence, the opposite party exhibited PAN card, being number such and such, exhibit 4, proved in original, a family ration card of his father issued on 1/5/93, exhibit 5, proved in original, a copy of the green card issued by the name of the father, exhibit 6 proved in original, a copy of the family identity card as Exhibit 7 proved in original, of the copy of the Gawabura certificate Exhibit 8. From the Exhibit 1 document, it appears that the Dauki immigration checkpost issued a certificate dated 25/6/1956 to the effect that one Rajkumar Das, son of Kushal Chandra Das, migrated to India along with his son Rakesh Chandra Das, with migration certificate dated 18/4/56 issued by the Deputy High Commissioner for India in Pakistan in Dhaka to settle at Tetliabadi in the district of Kamrup, Assam. Although the opposite party has claimed that the said Rajkumar Das was his father, there is no evidence that his father and brother are settled at Tetliabadi in the district of Kamrup after entering into India. The Exhibit 2 document is not a public document and is inadmissible in evidence. The Exhibit 3, land revenue receipt, though stood in the name of Rajkumar Das, the said land revenue was collected for the plot of land situated at Notun Khuti in the year 1965. And there is also no evidence to that say Rajkumar Das, whom the opposite party has claimed to be the father, initially settled at Ketlabari and subsequently shifted to Notun Khuti, wherein he possessed the land. Though by exhibiting Exhibit 2 and 3 document, the opposite party has claimed that his father migrated to India in the year 1956 and possessed the land in the meantime. There is absolutely no evidence to show that his father's name was entered into the voter list of 65, 66, and 71, and subsequently thereto. In the evidence, though the opposite party deposed that his father's name was entered in the NRC of 1951, white legacy data such and such of village Borailpara, district Kamrup, and produced a copy of the NRC details. The said NRC details shows that said Rajkumar Das, whom the opposite party has claimed to be his father, aged about 12 years in the year 1951. And on the other hand, the age of the Rajkumar Das, who migrated to India in 1956, and whom the opposite party has also claimed to be his father, was aged about 28 years in the year 1956. Thus, the evidence of the opposite party is itself contradictory, and due to such contradiction, the evidence of the opposite party cannot be relied upon as trustworthy. Since the opposite party has claimed the Indian citizenship through his father, the evidence of the opposite party is not sufficient enough to prove that he is the son of the genuine Indian citizen. For the aforesaid reasons and discussion, the evidence and documents exhibited by the opposite party in support of the case are found to be not sufficient and trustworthy due to contradiction and discrepancies of the document, and also the oral evidence to prove that he is not a foreigner in absence of any other supporting evidence, and opposite party has miserably failed to prove that he is a foreigner as envisaged in the Section 9 of the Foreigners Act 1946 with cogent and reliable evidence. Considering the entire materials on record and the discussion above, I am of the considered opinion that the opposite party's Rajesh Das, son of late such and such is a foreigner who entered into India on 15th to after 25/71 without having any valid document and without authority that he is termed as foreigner of 1971 stream. This is the evidence, madam.
How do you counter the finding of the tribunal in page 33?
Your lordship has rightly pointed out to me before this to me, but when if the migration certificate is considered to be a true, genuine one, then there is definitely a case for that my father entered. Now, my lord,
So then the NRC reflects a different age.
NRC has, my lord, yes, NRC I have annexed, my lord, 1951 NRC.
That is also your document.
Let's say I have not annexed it, my lord, here.
Oh, no, from
Oh,
the
yeah, I have annexed to page 28, my lord. Page 28, my father's name Rajkumar Das. Is 7.
your age is shown to be 12.
My lord, that is also another thing that there is, I don't find any or accept the image that is legacy number, but what is the date of issue, the year, that is also not is absent here.
You mean to say it is not 1951?
1950, I entered to 56, how can be 1951?
So which year is this written?
It is very difficult, it is not, say it is not there. And moreover, in my detailed statement, para 9, it is specifically mentioned that I was born in the village Natunkuti in the year on 2778. My father and mother came along, that is the family members. And the certificate that was issued by the border, there was the specific name of the family members.
Can you, Mr. Sharma, can you find out the particulars of this NRC details?
NRC details, Lordship, I will try, Lordship. Lordship.
Legacy data code is there.
Otherwise, Lordship, NRC is not an acceptable piece of evidence, Lordship. And Lordship, regarding Lordship, this certificate, Lordship, one Rajkumar Das, son of late Kushal Chandra Das,
My grandfather.
was reflected, Lordship. Rajkumar Das is
My
his
father.
projected grandfather. And Lordship, apart from that, there is no document, Lordship. Only 1997 voter list is there, page 21, where one Rajkumar Das name is reflected, son of one Kushal. That Kushal Chandra Das or anywhere, that was not reflected, Lordship.
You see, that is an accepted position. Even in my voters list, my father's name is incomplete.
Lordship.
First name is written.
Lordship. How he can prove, Lordship, his continuous
it's not
residence
that.
from the year 19.
No,
But please tell us, you see, you are representing the government.
Yes, Lordship.
Now, it is a statement made by me here in court that in my this voters list, my father's name is incomplete.
Lordship.
So only the first name is written,
Lordship.
and not first, Ishwar Rai. So that surname is not there.
Lordship, if we ignore that part, Lordship, then
No, not
also,
that.
Lordship.
You see, I'm trying to understand that if there's a match of Kushal,
Yes.
there's a match of Rajkumar Das, why? And the third part I've just discussed and then I'll tell. You see, the point which we just deliberated is that with that evidence before the tribunal, nobody questioned that part of the evidence.
Lordship.
Correct. No
State.
cross-examination on the point. The state did not do the cross-examination on the point.
Yes, there is
that
a suggestion.
that the Kushal is not Kushal Chandra Das. So therefore, for the court, when it's an issue not in dispute,
Lordship.
how can the tribunal later on say that this document is discarded just because of the fact that the name Kushal is there, Kushal Chandra Das is not there? Now this is number one. Number two, I always have this question. Give me this. Let me take presumption. This is 114 illustration E. All judicial and for official acts are duly performed.
Yes,
114
114. E. Judicial and official except,
regularly performed.
yes, true.
Now, if it is regularly performed, that's a presumption. To negate that presumption, the state will have to bring it and then say that no, like that UPSC now, the UPSC scam in Assam or NET scam in Assam. Now the CBI is unearthing and finding out and bringing before the court evidence that this act was not regularly performed. That there was that at particular place the box was broken, the lock was tampered, the documents were taken out, photocopied, circulated to a person who is in that what do you call it, the training academy. From there, it was distributed to these people. So this is how it is performed, and then it is demonstrated that the act was not not regularly performed. So in this case, how do you presume? That's why I was linking it that the names in the voters list, that once the central government accepts it to be correct,
Yes, sir.
and I am permitted to vote on the basis of that. So there is a presumption that it is duly performed. Nobody raised an objection. That is the reason for under 114E. That's why I'm,
Yes, Lordship.
once that presumption is drawn.
Mr. Sharma,
Yes, Lordship.
leaving everything aside, there is no objection from the state that
Yes, Lordship.
he is not the son of so-and-so who he projects to be his father, even if his name is not complete in the voters list or anything like that. There has to be some objection from the state.
Because you don't
Lord,
even question this document, saying that this is a false document. This exhibit 1.
How will you find the details to this document, page 14?
Page
14, immigration checkpost, authenticate. I think it is proved in original.
Concerned SP Lordship.
It was proved in
The
original.
original, it is reflecting the judgment.
Lordship,
Yeah.
let me take the instruction, Lordship, in respect of this document, Lordship. Para
No,
14.
you will not be able to get it unless you take the assistance of the
You did.
CGC.
Yes,
Because this is an immigration document, it will not be in custody of the state.
yes,
It will only be in custody of the central government.
yes, Lordship.
It's issued by a passport office,
Lord-
immigration checkpost.
Yes.
Please look at the seal. Entry at Dowki, immigration checkpost.
Yes, Lordship.
And next is passport checkpost, Dowki.
Okay.
Now, who will have this record? Please, first of all, please ascertain who will be having this record. Mr. Mehdi, please look at this document and tell us. It will be with the central government or it will be with the state government. Because citizenship is never a subject of the state. So ideally, it should not remain with the state.
Page number 14.
Yes, ma'am. Said by the deputies high commissioner for India at Pakistan. In Dhaka.
Because this is issued by passport checkpost.
Yes, ma'am.
So passport checkpost is within the domain of the central government. So state government will not be able to produce the instructions.
Certificate as small does also in access to India and
Yes.
Has to be this central government.
Yes.
পাসপোর্ট চেক করতে মেঘালয় সদর থাকে না চেক করতে What is the name of the petitioner?
Rajkumar, Rajeshwar Das.
Addition.
Rajeshwar Das.
And who is Rajesh Chandra Das? Rakesh Chandra Das?
Petitioner name, bucket. Rajeshwar Das. Rajeshwar Das.
My name is Rajeshwar Das, my lord.
Never, who is Rakesh Chandra Das? He is shown to be a member in that certificate at page number 14.
Name of the member is family member, my lord.
Family member son.
Son, one of the son.
So your brother.
Yes, not this son. He was born here, 78.
Rakesh Chandra Das. Was he before?
His age is 14 years.
Was he before the tribunal?
No, he was not called for. Only my name was called for.
No, but you did not bring him before the tribunal to say that he was your brother. Who is
That
named
I
in
have
this?
not. I have not.
In the document exhibit কইছে is it document exhibited Rajeshwar Das
Link document function. Link document. Link document function. Link document. Link document.
Oh, link. Nambura certificate. আছে আমি অরিজিনাল করেছি নিজে করেছি নবরা খানে এখানে রিফ্লেকশন নেই
Because Mr. Mehdi, you see, so far as the court is concerned, in the doctrine of non-traverse, this Union government is not coming and telling us that this document 1 is fraudulent. So therefore, it is admitted. Therefore, the court is not questioning this document. If the document is to be questioned, this question must come from you, not from the court. Because when there is no objection to this document, even at this stage, when the petitioner asserts that his father entered into India to the checkpost of Dauki, if this document has to be questioned, it must be questioned by you.
Yes.
And when, for you to question it, you must have something on hand to say that this document is questionable.
Yes, sir.
Some of your officer would have confirmed that this passport office never issued this certificate. So unless you two work in tandem in many cases, you'll not be able to assert which is which sort of be projected by the tribunal. You're not questioning this document.
And Lordship, apart from page 24, Lordship,
Yes.
there is no document to link up the proceeding with his projected father, Lordship. And that document was also not proved before the tribunal, Lordship.
Which one?
Lordship, page 24.
24.
There is Gaumura certificate.
24 you forget for the time being.
Yes.
But this also has this seal of state emblem. So you
Yes.
forget this document for a moment.
That's why, Lordship, I am saying, Lordship, except this document, Lordship, there is not a single document that.
No, there are voters
Rajasthan
list.
does
You
it.
see, one may be delayed in having this voters list name entered in the voters list. But there are voters lists to say that the name Kushal was there. He is ascertaining from different documents that he is the son of Kushal Chandra Das. So name Kushal is there.
Lordship,
That means 20% name is there.
Rajesh Sir Das, Lordship.
Huh?
Son of Rajkumar Das. Proceeding is Rajesh Sir Das.
No. This in this document one, the page 13, it
Yes.
is Rajkumar Das,
Is
son
the
of
father.
late Kushal Chandra Das.
Yes, Lord.
He is producing a voters list of 1997 saying that Rajkumar Das is the son of Kushal.
Okay. But
Then
here the proceeding is Rajesh Sir Das, son of Rajkumar Das.
yes,
Rajkumar Das is Kushala Bhutta. Rajesh Das to Rajkumar Bhutta.
97 voter list, my name is there, my lord.
Hmm?
In 97 voter list, my name is there, Rajesh Das, son of Rajkumar, age 24.
where is that?
That is page 22. It is a vernacular voter list, my lord.
It is not certificate.
English translation you are not given.
It's not a certificate.
Page 21. You don't give that English translation. And this document we can't read.
It's not a certificate to be loaded. Page 22.
Therefore, this is not a certified copy, it doesn't link. Therefore, only
What is the value of the Gaumura certificate?
Lordship.
this is what says, receipt
Lordship.
says,
Value of the Gaumura certificate.
14 page 14.
Actually, Lordship, law is that Gaumura cannot issue such certificate, Lordship. As per Lordship, executive instruction, Lordship, Assam Land and Revenue Manual, Lordship, and Lordship, and also Lordship, law regarding that has been already settled, Lordship. If a state emblem is embossed at the top of the death certificate, that document is not admissible in evidence law.
No, that, but we want to find out what is the effect of a Gaumura. There are orders of this court.
Yes, Lordship. Yes. Yes.
My lord, with regard to Gaumura certificates, the this honorable court has settled that the Gaobura certificate, in fact, Gaobura cannot issue citizenship certificate under the executive instruction of my lord, Assam Land Review Regulation. So
No,
in fact, he
this
cannot
is a
issue that.
residency.
Yes, this is only for the residents he has issued.
No.
So he cannot, in fact, this power has not been given to my lord, the Gaobura. There is no power under executive instruction of Assam Land Review Regulation to issue such kind of certificate by the Gaobura. Second thing, my lord, if the Gaobura issue a certificate, like my lord, the Panchayat secretaries, in fact, the Honorable Apex Court has given the Panchayat secretary can issue certificate in case of married woman to show that that after marriage, she has transferred the, my lord, she has shifted her residence. To that effect, my lord, Supreme Court has allowed the Panchayat certificate for the purpose, that purpose. And in that case, it has to be proved in two ways. First of all, authenticity of the document itself. Second, the authenticity of the contents of the document, of that certificate. So on that two riders, my lord, Supreme Court has allowed this can be used for the purpose of married woman if he transfer his place of residence after marriage, my lord. But it is not allowed for the, my lord, male persons. It is only for the married woman. So in that context, if we accept also in the same parameter, my lord, that Gaobura can also, on that same basis, in that case, my lord, also we can say, okay, in case of married woman, my lord, the Gaobura may sometimes issue certificate that yes, she got married to this on so and shifted this residence from so. And that has to be proved, first of all, my lord, on the basis of contemporary record. Secondly, that whether the Gaobura has issued the certificate is authenticity of the certificate, and secondly, my lord, the authenticity of the contents of the certificate. That has to be proved. So that is another aspect. And third aspect, my lord, the Gaobura and Panchayats are not allowed to use the national emblem of the country. That is another.
That is accepted. So how have you projected your link between Raj Kumar Das?
The Gaobura certificate, if your lordship accept it, my lord, is my father's name is there.
That is only residency.
Yes. Resident, since my father has been mentioned that I am a son of his, that residential area.
No, it shows that Rajeshwar Das, you're Rajeshwar.
Yes.
One Rajeshwar Das, son of one late Rajkumar Das, was a resident.
Yes.
You have to establish the link
I am that
between Rajeshwar Das and Rajkumar Das, the person who entered through Dauki. That connection you have to establish.
Yes, my lord.
You are the person of that particular.
Difficulty is that, my lord, that it was a document pertaining to 1956, and my lord, I could not bring that very person of issuing authority.
No, that is proved in original. There is no difficulty there.
The only content remains. Doubt remains whether he was my father.
No, that's all right.
Yes.
But there was one brother mentioned there.
The brother is there.
Ah.
I was not born, so my name cannot be there.
Of course,
yes.
But you could have at least, just thinking aloud, that if that brother was brought as a witness in your favor to say that yes, I am son of so and so.
Even my statement was not recorded. That is a fault on my part.
You don't have a birth certificate.
This man is illiterate man, my lord. Nothing of that. Nowadays we are giving importance for birth certificate.
Those Mr. Frank. You see, we have referred to it earlier. In the cross-examination, you don't put these questions. Now, therefore, what has happened, and evidence is introduced.
Yes.
Correct. There's no cross-examination to the petitioner on the correctness of the evidence given. Now, so far as we are concerned, the requirement of the Evidence Act I hope Evidence Act is applicable in this, there's no exclusion of Evidence Act here in this tribunal proceedings.
My lord, not in all cases, my lord, because
No, is it excluded? Evidence Act will not apply.
Spirit is followed, my lord.
The spirit is followed.
In the summary proceeding, my lord, so
Just a moment, I'm looking at something. The comparative chart is not there. Nine.
Your father did not depose.
No.
Father, mother, and nobody.
but mother's name is not mentioned in the WSS. Who is the mother, my lord, that is still unknown.
Where is the WS?
WSS. Page
It's
29.
29 WS.
Eight. 45. When is Hillman to report to submit certain reports? Particularly, every village headman, village accountant. Government residence of any property. Mr. Payang, contrary to what you are saying and contrary to what are the decisions of this court, a village headman, please read that power again. Village headman power is under land revenue regulation.
Yes.
Correct. Now we'll show you something. Yes. C 164 executive instructions.
163, my lord.
164 last.
164.
Duties.
Yes, my lord.
Correct. Come to next page. 1, 2, 3, 4.
Oh, my lord.
What does it say?
Except under the special orders of the state government, the connection of Gaobura with the police will be limited to making of reports under the section 45 of the criminal procedure
Correct.
code.
Now stop there. You can continue reading, but for the time being, stop here. Now, naturally, when this was amended,
Yes.
1973 CRPC was not there.
Yes.
So it will be CRPC 1898. Correct?
Yes.
45 is there. Now read 45.
Every village headman, village accountant, village watchman, village police officer, owner or the occupier of land, and the agents of any such owner or occupier and every officer employed in the collection of revenue on rent of land on the part of the government or the court of wards shall forthwith communicate to the nearest magistrate or the officer in charge of the nearest police station, whichever is the nearer, and information which may obtain respecting a the permanent and temporary residence of any notorious receiver or vendor or stolen property in any village of which is headman, accountant, watchman, or police officer, or in which he owns or occupies land, or is agent or collect revenue on rent. That is number one. The restore of any place within or places through
So
just
correct.
or any person.
Now you see this number 1.
Yes.
He will report residence of the notorious people.
Yes.
Correct. That means he must know who is the resident of where.
That is
To report notorious people, he may not report non-notorious people, but notorious people he has to report. Therefore, he must know who are the residents in the locality. And under the Assam Land and Revenue Regulation, executive instructions,
Yes.
you will find that there is a requirement of law to have a Gaobura for a.
He should keep records of.
No. There is a requirement of having a Gaobura for 150 families.
Yes. In each village, my lord. It is
In each
100.
village, 140 is one lot.
Yes.
So, and there is a negative clause saying that it is not required to have Gaobura in every nook and corner where there is sparse population, forest or other areas. So there is no requirement. So number 1, 150 families. He has the charge of 150 families. 45 says he must report notorious residences. So he knows about the residents.
That is true, my lord. He should know actually what my submission is. He should know. My lord, is this
No, now the fact is, if you admit that he should know, where is the negative evidence that the certificate produced by him, the entry, was incorrect? Apart from that, what do you call, Ashok Stamp.
residence of person can be. Yes, I admit, my lord, residence, that he is a resident of this village or he is not a resident of this village. This may be given by him, but citizenship he cannot give. That is first issue. Secondly, my lord, this is a negative, my lord, proposition, negative, my lord, ways. That if the Gaoburas were so vigilant, my lord, this disturb would not have come. It was the initial, my lord, the Gaoburas should have reported all these persons who ever entered in the very first day, my lord. If they could report it, this, my lord, entire issue would not have come. But Gaoburas did their own works, my lord. In fact, what I will submit for that. They should have reported the notorious persons.
So fix it for hearing in the meantime.
Yes.
You'll have to take a about this lecture 1.
Yes, this is, my lord, this is some extent, my lord, what I submit. If I go through this, my lord, annexure and other facts and circumstances of the case, this is very absurd. Because in the annexure, my lord, if your lordship see, Rakesh Chandra Das, son is shown to be 14 years in 1956. Then who is the mother? And whether mother was entering along with them, that is not mentioned. And now suddenly, the petitioner is shown to be born in 1978. That means after 36 years of the elder brother. In between, there is nothing. Who is the mother?
No, these things you never question.
No, my lord, this was not in fact exhibited, but this is first time probably brought before this honorable court.
No, court has mentioned in the opinion, proved in the original. Because Hasan, thank you.
Yes, about the lecture one, you will, Mr. Very, you'll get information on this, this lecture one.
Sometime maybe I'll write you because.
Copies of the date, page 13. We'll have a copy. Just give a copy of the
I'll give.
registration to him, along with the lectures. Which is represented. See. TCR of the Congress having this
Order to देखा हो जाएगा.
This is nice. Ability for hearing, issuing rule and tenable forfeit without requiring the petitioner to take rest. Important. So J. Pahang Leonard, Sternicus for the FT.
It is the tribunal Congress
Has question the correctness of Annexure 1 to the petition, which is an extract of entry dated 25/6/1956 under serial number 102-103 issued by Tauki Immigration Checkpost, which bears the round rubber stamp of passport check gate Tauki, certifying that Sri Rajkumar Das, son of Kushal Chandra Das. What is this L? I think this is overwritten, something L. You have the original one, no?
Yes.
You have the original one.
I don't have original mallet, but the copy I have given to your lordship mallet, the same almost.
It's here. Which copy? Which copy you have given? Chandra Das, CH Das. Is it 28 years and migrated to India? Along with his son, aged 14 years. Post. Same thing. No. Accordingly, the Mr. Esquimedil and CEC shall obtain instructions with regard to the said document. Next, the learned counsel for the petitioner shall provide a copy of the read petition with all inclusions to Mr. Esquimedil and CEC to enable him to obtain instructions. Next one. Client you date after 4 weeks. 4 weeks. First. 21st August. Okay. Discuss my name is because sometime there. Actually, only one day we are allotted some days.
So you maintain your own diary.
Yes.
You maintain your own diary. Why are you burdening the registry? The ASGI is already reflected. You maintain your individual diaries, which matter is there, on which date.
18.
Yes.
Miller. LCR received Miller, already admitted Miller. Petitioner is interim. A matter may be fixed for hearing Miller. As per my learned friend also agreed Miller.
Those are good points. Yes. Because you see, you see this, the evidence projected is with regard to the name, wrong spelling, name of
Yes.
so and so, and so and so.
Yes.
For that, your self-declaration would not be enough.
Uh,
I think we have judgment of this court also on the points.
And my lord, his name appear along with the parents, my lord, in the voter list of 1997, my lord, in the same village. But only for discrepancy in the name of father, my lord, petitioner declared as a father.
No such analysis. It's a fact that he died before my father was born. He said. So Martin, this the cross-examination of this DW1 has washed out the evidence. He has admitted that his father was born. His grandfather was born. Had died before he was born. Grandfather. Your father died in 2000. Your name is Abdul Bari. Yes. Your name entered into the voters list on which date?
On 1997, page 35.
1997.
Yes, page 35. At the age of 20 years.
But you see, how do we accept what you are saying? In your evidence on affidavit.
Seat matter. And that is the evidence in seat matter.
That is okay.
Yes.
In evidence in this
Yes,
is
it's
this is otherwise an affidavit in evidence.
Yes.
Whatever you write.
In the written statement also.
No, here you say, you see, I, Abdul Bari, aged about 38 years, son of Abdul Sabur. Correct. Then you give exhibit 2. In the exhibit 2, the name of the father is Abdul Sabur Sarkar.
Yes.
Now, how will you show that this is your father? In your affidavit also you have disowned that Sarkar. Paragraph 4, you say my father's name is Abdul Sabur. That means you are disproving this entry of serial number 351. So if the 66 goes, then there is no link.
Then my lord 66 will go to my lord, then my lord 1970, 89 also goes.
1970 also same.
Right.
It is Abdul Sabur Sarkar.
This border list. Yes. Herein up to my lord in 1989, my lord. Abdul Sabur.
No, we don't know anything.
Sabur
We
Sheikh.
just looking at it.
Abdul Sabur
89
Sarkar.
is Abdul Sabur Sheikh.
Yes. Abdul Sabur Sarkar also is here.
No, SK is not Sarkar. It
Sheikh.
cannot be Sarkar.
1970 voter list, my lord.
No,
Abdul
you
Sabur
see,
Sarkar.
no, Mr. Makeri, if everything else goes, after this 1970, there's no point looking at any other voter list.
Yes, my lord. Only for discrepancy of name, my lord.
It's a major in your affidavit, you don't say. No, in your affidavit, you don't say that is your father. Sarkar is your father, you never said. Or if you have said, I have missed it. You don't say Sarkar is your father. So 66 and 70 goes. Then you have to tell us the things. You see, we'll show you, come to this page, page 65. Oh, no, not 65. In your evidence, what is the page? Please check it up. Evidence on affidavit, where is that? Which page?
It's 61.
61. 61.
Here is my lord, Abdul Sabur and Abdul Sabur Sarkar is the same, and one person has mentioned in the paragraph 7, page 64. Abdul Sabur and Abdul Sabur Sarkar is the same and one identical person. That is my deceased father.
Mr. Martin, we find it difficult. We have shown you that you have said in your cross-examination that your grandfather died before you were born. Correct. Now, in your evidence on affidavit and your written statement, you say that the spelling of my grandfather was wrong. How do you know that?
That part, my lord.
And the reason why we find it difficult is come to page 68. Para 1 to 15 are true to my knowledge. And in para 8 of the evidence, you say that your father's name is wrongly spelled. Now, you could not have that knowledge.
1 to 15 is mentioned as a knowledge.
Because if this part of the evidence goes, then the second part of your case is with regard to that exhibit 5. But again, your village is different. NRC is of different village and the exhibit 5 is of a different village.
Exhibit 5, total list of 1997.
That shows one Abdul Saburuddin.
And the village is same, my lord. Beguntuli, my
In
lord.
51 of village, Beganatuli and Kherwar are two different villages.
Beguntuli.
These
Village
are
is same. '66, 1970, 89 or 97 or village are all are same, my lord. Beguntuli.
because they can be understandable that okay, one name or two name is different. Here, every name is changed. Grandfather's name is changed, mother's name is changed,
It's
father's
the
name is
model is
changed.
prepared by the authority, my lord. The petitioner is not the author, my lord. Model is prepared by the election department, my lord. The petitioner is not responsible to enter the wrong name, my lord.
But the self-serving evidence of a person is no evidence at all.
Only he has the defense deposed, my lord. And no other independent witnesses are not examined.
No, you see, because you see self-declaration, this can't be accepted. I always give a small example in horrible examples in my proceedings. You see, not say I, let us say A swears an affidavit saying that he is the owner of Taj Mahal.
And my lord, this part, my lord, did not rebuttal by the other side, my lord.
No, that's not fact. You see, what you assert, you must show. So we are just asking you how you are showing. Because you see, A comes and files an affidavit saying that he is the owner of Taj Mahal. He has very good relations and 10 members in the bar also say that yes, it's okay. I know that he's a owner of the Taj Mahal.
And my lord, there is no other option, my lord, except my lord stated in the written statement or evidence. The Abdul Sabur, Saburuddin, and Sofur, my lord. There is no other documents, my lord. And no person can establish, my lord, one point so and so are the same and one person, my lord. There is no other document, there is no any other. And that part, my lord, evidence in C for my lord, cross, my lord, that part not rebutted by the state respondent, my lord. That is the admissible, my lord. Our High Court judgment is there, my lord.
Where is that?
Yes, my lord, that may be given, my lord. I am giving citation, my lord, as per my lord, on the basis of a discrepancy in the name on age, my lord, and the evidence of the petitioner, my lord, that part not rebutted by the respondent side, my lord. There is a judgment, my lord, I will produce, my lord. And matter may be fixed for hearing, my lord. Further to-
See, all sides are duly represented. The next para, the trial court records of the FTC is received. Next para. Petition is submitted for hearing by issuing rule reasonable appropriate without requiring the petitioner to take first steps. Next para, this is the matter for hearing on. Give the same date. Last date we fix for hearing. Hearing this concerns for
21/8.
for hearing.
Item 19.
That's right. Yes. Yes. Yeah, before that, you are ready for hearing? Because we don't want to spend time and then say that the matter is adjourned. We fix a date. Same order. Which as a representative.
Hearing মঙ্গলবার বৃহস্পতিবার দিনে ডেট এই যে সারি করতে পারবো
Tuesday, Thursday.
after 4 weeks Tuesday Thursday.
Same order. Also as a representative. This is a matter for hearing. Okay.
Item 21.
May I please, lordship, please.
Same question, you are ready for hearing?
My lord, subject to your lordship's permission. Yes, my lord.
I didn't get it. You are ready or yes or no?
Ready, my lord.
Ready, okay.
My lord, page 42 is the impugn order, my lord.
Just a minute.
My lord.
No, this matters has to be adjourned. The division bench one will resume again. The brother has to leave.
So 22 after 4 weeks hearing date.
When we saw it, usually you know, but very essential. We have to on shot. Hearing day video. All these matters would be adjourned because you'll have to break.